Good afternoon, folks. I'm sorry that it's a little bit late, but we are going to get started here. So I'd appreciate if everyone would be taking their seats. We're going to go ahead and start today's meeting. I apologize that we're starting a little bit late. We were having just a few technical issues, but hopefully, I think everybody in the room can hear me, but hopefully everyone online can also hear me okay. We really appreciate you all coming and joining us for this meeting. And we're going to go ahead and kind of jump into our presentation. I am going to do some introductions here first, and we'll talk a little bit about what's on the agenda for today's meeting. My name is Natalie Mast. I'm the Active Management Area Director at ADWR. I have a few staff with me today, and part of why we wanted to bring the number of staff we brought today is because these are the folks that you're going to be interacting with throughout this process as we work through grandfathered rights, as we work through the management plans, as we work through all of the details of establishing this active management area. So we want to make sure that you're familiar with these folks and feel comfortable reaching out with any questions that you may have. Something we are working on is how can we best engage with this community? And one of the ways that we're doing that is we're having things like online office hours where staff are available at a set time every week to help answer questions. If you have specific questions on applications, for example, you can come during those times, and if those staff who are online are unable to answer those specific questions, they'll be able to get you in touch with the correct people who will be able to answer those questions. So I'll go around and kind of introduce the folks we have in the room here. At the very back, at the sign-in table, we have Teresa Marks, who is our outreach coordinator. Also in the back is Brandon Tallman, who is our data specialist. And then over here we have Sarah Leopold and Ben Calleros. Sarah and Ben are both attorneys with the department. Mike Ortiz is the Active Management Area Establishment Coordinator. Michelle C. Benali is our AMA Program Manager. And I forget if I introduced myself, but my name is, I'm cutting out a little bit here. My name is Natalie Mast, and I'm the Active Management Area Director at ADWR. All right, we are on the agenda slide. Thank you, Mike. So what we're going to cover today is an introduction to management plans and how management plans function in an active management area. We're going to first review some general information about what active management areas are, and then we'll really dive into what a management plan is and the purpose and function of a management plan. As we were thinking about today's meeting and developing what might be most useful for the time for today's meeting, we realized that it might be useful to take a little bit of a step back. As we started having meetings here in Douglas, we really had to jump right into things and start talking about the development of the goal and that type of thing. So the first part of today's meeting, you can look at the slide, Mike. The first part of today's meeting is really going to be a little bit of a step back, and we're going to unpack a little bit about what an active management area is and what it does, and how all of these different components of an active management area fit together, and also how we think about groundwater in the context of an active management area. So I will try to move slowly here. I do have a tendency to talk fast, so you feel free to pipe in and tell me to slow down if I need to. Yeah, we really want to take this time to contextualize, to talk about the active management area in order to contextualize the next part, the management plan, and how we're going to develop that. So thank you, Mike. All right, so as you can see in this map, many of you are familiar with this. The Douglas Active Management Area covers a larger area than the previous irrigation non-expansion area did. This is because of a statutory requirement that subsequent AMAs, which Douglas is a subsequent AMA, subsequent AMAs must be based on groundwater basin boundaries. So that original INA, was based on a grid system. It was based on a cadastral system. And so it didn't cover the entire Douglas groundwater basin. So when the active management area was created, the requirement in law was that it be based on those basin boundaries. So you can see kind of that edge around the former INA, where the AMA covers the entire basin. So those boundaries were slightly expanded to include the entire basin. The Douglas AMA is the first subsequent AMA, and it was established by local election on December 1st, 2022. The entire AMA is in Cochise County, which is what we refer to as a mandatory adequacy jurisdiction. I'll talk through a little bit of what that means later in the presentation, but the scope of that particular requirement is really related to subdivisions, new subdivisions. Next, thank you. So the statutory structures for active management areas were established in the 1980 Groundwater Management Act. This act was passed really with the idea that conserving groundwater and regulating groundwater depletion was critical, was important to the economy and the general welfare of the state of Arizona. In order to address those groundwater declines that we're seeing then, this tiered additive system was put into place. So there are different requirements within the state of Arizona depending on the level of groundwater management that applies in a given location. So statewide, everyone is required to register wells. If they're drilled, if they're deepened, if they're modified, there's a registration and documentation process associated with that. Statewide, everybody is subject to adequate water supply requirements, which is a little bit different than the mandatory adequacy that I mentioned earlier. Again, I'll talk more about that a little bit later. And statewide community water systems, so water systems that are serving a certain number of customers, are required to report their water use annually to the state, and they're required to submit system water plans every 5 years. So that's statewide requirements. No matter where you are in Arizona, those requirements apply. In irrigation non-expansion areas, which many of you are familiar with, there are additional requirements. So this is an additive system. So those initial requirements apply, those statewide requirements still apply, and there are additional requirements that apply in an irrigation non-expansion area, which is that the acreage of irrigation can no longer be expanded in those irrigation non-expansion areas. So it's just what it sounds like. New acres cannot be irrigated, and there are measuring and reporting requirements for those that are using non-exempt wells. And we'll talk again about what that means in a little bit. So folks have to report, if you're using water from a non-exempt well, you have to report annually to ADWR how much water you're using. In an active management area, again, those previous requirements all apply. We've got registration of wells, we've got measuring and reporting, we've got the irrigation non-expansion, and in addition to that, there are more requirements that apply, more complexity in an active management area. So an active management area is the highest level of groundwater regulation in the state of Arizona. So assured water supply, which is similar to adequate water supply, but there are more stringent requirements that apply, and it's a permitting step rather than a notification step as would occur under regular adequate water supply. Management goals, plans, and conservation programs. We're going to be talking a lot about that today, so I'm not going to go into detail on that. But hopefully you all will walk out of this meeting today with a better understanding of what we're referring to with that line item. We've talked in previous meetings a lot about grandfathered rights, and I'm gonna talk more about it today because it's really important for you all. And in addition to all of those, there are also other requirements that are kind of more detailed. Things like requirements about new lakes and moving water and those types of things, well spacing. For wells, there are two classifications for wells, and we've talked about this before, and I'm going to unpack this a little bit and maybe simplify. So this is kind of the complicated version, and then next I'll simplify a little bit. And the reason I want to go complicated first is because I want to get across that there are many exceptions to many things. And I guess that's just the nature of some of these regulatory requirements. So there are two classifications for wells: exempt wells and non-exempt wells. Exempt wells are kind of what they sound like. They are exempt from many of the regulatory requirements that apply in an irrigation non-expansion area or an AMA. So an exempt well is not going to be required to measure or report their water use. Generally, a person may withdraw groundwater for a non-irrigation use from a well having a pump with a maximum pump capacity of 35 gallons per minute or less without having a groundwater right or permit. So again, exempt. Generally, those small wells, less than 35 gallons per minute, used for non-irrigation uses, are able to be exempt from reporting requirements and will not be required to have a grandfather right.
Quick question, but they are registered.
They are still required to be registered. Yes, that's correct. That's a good point. Thank you. So there are limitations here though. An exempt well, you can only have one exempt well within the same location used for the same purpose. So this isn't a thing where you can have 3 exempt wells right next to each other using less than 35 gallons per minute to get around this requirement about exempt and non-exempt. And an exempt well cannot withdraw more than 10 acre-feet per year for a non-irrigation use. Now, again, our definitions of irrigation here are important. Irrigation, in the context of an AMA, is applying water to 2 or more acres of land to grow plants or parts of plants for sale or consumption. So if you are irrigating a 3-acre field for pasture and there are animals grazing on that, that is consumption. So that would be classified as irrigation. If you are watering a 1-acre garden, that's not going to be classified as irrigation in our definition, because that's less than 2 acres. It's 2 acres or more of water applied to the land to grow plants for sale or consumption. Something important here, and again, we're going to emphasize this multiple times, pretty much in every meeting that we have down here through March, there is a deadline. If you are using water from a non-exempt well, you must apply for a grandfathered right by March 1st. There are no exceptions to that deadline, and that's why I want to emphasize this multiple times in every single meeting we have down here. There are no exceptions to this deadline. ADWR does not have the authority to make exceptions to this deadline. So if you are using water from a non-exempt well, if you are irrigating 2 or more acres of land, if you're using more than 10 acre-feet for a non-irrigation use, you must apply for a grandfathered right in order to continue legally using groundwater in the active management area. Next slide. So here's where I simplify a little bit. An exempt well is 35 gallons per minute or less, uses less than 10 acre-feet, and is not used to irrigate 2 or more acres of land. If you can check all 3 of those boxes for your exempt well, then you will be exempt from reporting requirements, and there is no requirement to obtain a grandfathered right or withdrawal authority. And to your earlier point, you do still have to register that well. Those well registration requirements apply to all wells, no matter the size. One more time emphasizing that deadline. The grandfathered rights deadline is March 1st of this upcoming year. So we're less than 6 months out from that. Yes, sir.
Did I understand you to say that my 35 gallons per minute exempt well, I've got to register that by March 1st or not?
All wells must be registered statewide. So that well theoretically should be registered now.
Like, does the village permit register it?
So yes,
So they're already registered?
right.
That was a previous requirement.
Yes, that was a previous requirement. That's not a new requirement here. That's a requirement that gets included because those previous requirements still apply. Yes, good. Sorry.
Ma'am, I know of 3 wells on property I purchased that are not registered, and therefore I called, when I bought it and went to the company on the insurance, we called the state of Arizona and they issued us the permit for the well, and they were not registered within the state of Arizona.
Okay.
They were all in excess of 200 feet and 8-inch steel casing in them. And the state of Arizona Department of Water Resources had no idea about them at all.
And that does happen sometimes.
Didn't
If there-
happen once, it happened 3 times.
if there-
That's kind of an oddity.
If there are instances like that, we do have a late registration process that you can go through to make sure those wells are properly documented.
You guys registered them already through the
Yes.
insurance company, but I'm telling you, you're wrong, they're not all registered. And just because somebody drilled them doesn't mean they're registered.
The
I have to know
legal,
that because my dad was a well driller for 40 some odd years. And
Thank you,
I
sir.
know what's going on, and it's not true, so don't be insinuating to people that they are registered because they may not be, even though they are non-exempt.
there are certainly wells throughout the state that are not registered. The
Yes.
legal requirement for them is that they need to be registered.
You're saying.
So if you know of a well that is not registered, there is a late registration process that you can go through with the department in order to register that well. All wells across the state must
The
be.
rules. She just.
I know, but Kamala
She just
doesn't.
said the rules, what the rules are, that there has to be registered.
They're supposed to be.
Yeah, if they don't get registered, that's somebody else's fault, but.
In that situation that Mr. Moore just described, is there a fine associated with wells that are not registered?
I don't know that information off the top of my head, but I can make sure to follow up on that at the next meeting.
Yeah, we've been on our ranch here since the late 1800s.
I'll make sure to follow up on that information at the next meeting. I appreciate
How
the
will we
question.
get it? Will you email it out to the
Yes.
mailing list?
Sure, we can do that, yes. Thank you. All right.
Staff took a note of that, right?
Yeah, I've got folks taking notes for me, appreciate it. Yes, all right, so all of those details on the previous slides are important. Obviously, that March 1st date is really important. If you could go back to the previous slide, Mike, thank you. Something I want to emphasize here, and I said this before, ADWR does not have flexibility on that March 1st date. If you do not apply for a grandfathered right, so sorry, let me back up. If you are using water from a non-exempt well and you do not apply for that grandfathered right by March 1st, you will be deemed to have waived and relinquished any right to use groundwater in the Douglas Active Management Area. So that's really important, and that's why I really want to emphasize the importance of applying for those grandfathered rights.
That's a kick in the ass out there.
Quick question is, once you have put in your application, when do you let a person know that you've received it? Because you might send it in and think that you've received it and the date passes, and then you guys can turn around and say you never received the application.
Sure.
How do we get past that? Because a lot of people have applied, but nobody's heard back yet.
It's a really good question, and I do apologize for the delay in kind of those notifications going out. Like I said, Douglas AMA is our first subsequent AMA, so a lot of these processes we're working through for the first time. So we have started receiving applications, and staff are working on a process to promptly send out a confirmation letter once we receive an application. What you'll get is a confirmation letter with an application number associated with it. It's a 79 number. So there will be an application number that'll start with 79 dash some additional numbers. And you keep that application number, that's what we're gonna use to track each application. We do have a timeline in the Douglas AMA, so we're not gonna be able to issue any decisions right away. So after March 1st, we will issue a list of all of the applications that we've received. At that time, anyone in the basin will have 180 days to submit written objections to any of the facts of any of the applications we've received. So after that 180-day period is when we'll be able to start actually issuing decisions and issuing those grandfathered rights. So it won't be until late next year that we'll start issuing grandfathered rights for the Douglas AMA.
So you just said that once that list is published, that anyone can refute whether or not that permit should be issued. So the public can comment on everyone else's wells, is that correct?
Yes, give me 1 second here. There's specific, am I looking at the right one?
Because it makes a big difference if it's just you want more information, right? Or my neighbor is like, well, she's using more water than she says she is, versus someone who lives in the city of Douglas complaining about an irrigation well.
And by law, any person residing in the active management area may file written objection to any application. And objections may be made only on the basis that the information in the application is incorrect or insufficient.
Thank you for the clarification.
And notices are going to all of the residents?
Yes, so notices have already been sent to all property owners about that deadline. We are going to be sending an additional courtesy notice to all property owners in the near future here, I was just talking about that on the way down here.
When, something you just said earlier about if I don't file on my irrigation well, I hope you left some words out of that statement. Because what I heard you say was, I lose all rights to withdraw any water within the basin. Or is it just all rights to withdraw water from that well?
So it would be pursuant to a specific application. So.
A specific well?
Yeah, so it's not necessarily gonna be associated with a well, it's gonna be associated with a physical, like, land footprint.
And that footprint is?
So the footprint that we'll identify for irrigation grandfathered rights it'll be the lands that were legally irrigated in the 5 years prior to the freeze on irrigation, which went into effect on August 30th of last year. And all of that information is available in those online applications.
So it seems to me, since you are backed up stuff, that you guys with non-exempt wells ought to be very careful that you make sure you, I did fill, you have receipts for yourself that you did send us information.
Definitely, yes.
It seems to me they really need to be careful. I have an exempt one, so.
And so we did create an online application submission portal. So that rather than mailing your application in, for example, if that might make you a little bit nervous, there is an online submission tool so that you can immediately get a confirmation number through that online tool. We'll immediately get a notification that online application has been submitted. There's going to be a little bit more guarantee that it's instantly happening in that kind of sense for that online tool. Good. Okay, good. I appreciate the questions. For non-exempt wells, with just a few narrow exceptions, folks withdrawing water from a non-exempt well are required to measure their groundwater use and report that groundwater withdrawal to ADWR on an annual basis. I want to be careful about the dates here because this date for annual reports is March 31st. Annual reports are due March 31st each year, but that application deadline is March 1. So be cautious of making sure that you have your dates right there. We do have specific rules adopted for what those measuring device requirements are. Those are available on ADWR's website.
Are you gonna buy them?
In addition to measuring and reporting requirements, there are also what we call well impact analysis or well spacing requirements for non-exempt wells. So if you're drilling a new non-exempt well in the active management area, you'll have to do a well impact analysis to demonstrate that you're not causing unreasonable harm to surrounding wells by the expected withdrawals from that well. So there is a process associated with that, and that's for new non-exempt wells. So that wouldn't apply to an existing well that you're deepening. That wouldn't apply to a replacement well within a certain distance of the previous well that you're just replacing.
Who does that analysis? That doesn't sound like something you can sit down at the kitchen table and do in 5 minutes.
Is it,
Just a drill company will
I
hire
think
something.
it's the company, yeah. There are contractors out there that will do that type of analysis for you. I am not perfectly familiar with that process, but perhaps at a future meeting, we could have someone come and provide a little bit more detail about that.
The estimate would be a nice thing for everybody to hear.
Okay, sure, yeah, and I don't know that number off the top of my head, but we can certainly provide that. Thank you.
No,
Yes.
Is there any provisions, I'm not hearing you say there are, but I just would like to clarify. Is there any provisions for the fact that one irrigation well done and well managed versus is gonna be monitored and required to report and all that kind of stuff? But if 10 people move out to the area, each of them drill a well, they're all non-exempt because they're all residential. They could have potentially in the long run, have a much greater impact, depending on how their wells are spaced and managed. Are there any provisions for that kind of thing, unless I realize a subdivision or housing development there is, but ex-urbanization type moving out, is there any provisions at all?
There are restrictions on how close an exempt well can be to the service area lines of a designated water provider. But exempt wells are exempt from a lot of these requirements by statute.
Right.
So in very, very broad generalities, in most cases, if they meet those 3 criteria we talked about before, they're going to be exempt from any type of impact analysis or other types of requirements.
And those are limited to the 10 acre
Right,
per year.
right, no more than 10 acre feet.
Right, and less than 2 acres. I'm just picturing, we've had a lot of people move out, especially during COVID, and there's a lot more people living where there used to not be. So it seems to me you're missing a piece of the water management puzzle.
We have certainly heard consideration of that type of thing as a part of our data analysis in active management areas. We do create estimates around those exempt wells to kind of consider whether we think that impact might be negligible or whether we think it's something that might need to be considered more seriously. So it is something we create estimates at least around, even if they are not specifically regulated in that way.
Okay, do these people that are moving in, do they have to apply for a permit to drill before they drill? And then you make sure that this is a certain distance away from other wells?
So they would still have to apply for a permit to drill because everyone has to do that, exempt or non-exempt, right? But the well spacing requirements apply specifically to non-exempt wells. So it applies specifically to those larger wells and would not apply to the exempt wells. And that's by law. Good questions, I appreciate it. Thank you. All right, let me just make sure I covered everything.
Natalie, if I could jump in really quick.
Oh,
Just
sure.
to answer a previous question, for the late registration of a well, there is a $60 fee. I think someone had asked earlier if, yeah, so $60. Thank you.
You say 6 or
60.
6?
Yeah.
Thank you.
Okay, if you could go back to the previous slide there, Mike, sorry. Actually, one more back. Something I did want to note with the grandfathered rights, we have 3 types of grandfathered rights. So this is not just irrigation that would need to apply for a grandfathered right. Irrigation is obviously one of those 3 types of rights, but there are also 2 types of non-irrigation rights. So if you're using more than 10 acre feet for a non-irrigation use, you would need to apply for a non-irrigation grandfathered right. Type 1s are non-irrigation rights based on a prior retirement of agricultural land. The applicability right now in the Douglas AMA for this is going to be pretty limited, but it is something that's theoretically possible. A type 2 is a non-irrigation grandfather right that is based on prior non-irrigation use. So if prior to the establishment of the AMA, you were using more than 10 acre-feet for a non-irrigation use, so that's pretty much anything that's not irrigating 2 or more acres of land. So if it's a dairy or airport or whatever the case may be, if you're using more than 10 acre-feet for a non-irrigation use, you would apply for a type 2.
Do those rules and statutes apply to Arizona Game and Fish Whitewater Drought?
Everyone who is using more than 10 acre-feet, yes. Right. Yes, thank you. Sorry, I'm gonna touch one more point on the grandfathering rights. I'm just going back through my notes and making sure I'm not missing anything since we're jumping around a little bit here. For those applications, I mentioned those office hours earlier. Those are a time when you can touch base with staff, get some of these more specific questions answered. What I would like to point out though is that staff cannot provide legal advice for you or for your specific situation. So there may be instances where we're just unable to answer a very specific question, and we may recommend that you instead seek legal advice for your situation. Thank you. Yeah. All right. So far what we've covered are the kind of general requirements that apply in all the AMAs. You've heard me reference the statutory requirements, the laws, a whole bunch of times already. What I really want to talk about now is the management plans. There's some statutory structure around management plans in an active management area, but these are where the requirements that we can really customize for an active management area are going to be contained. So in particular, those requirements in the management plan are designed to change over time. So the way that would work is with gradually increasing conservation requirements over time, creating incremental improvement in the active management area over time, trying to move the active management area toward its goal. So thank you, Mike. The statute on the screen references the initial AMAs. So I'm going to be pointing back to this, but also clarifying how this applies to Douglas. The statutes for the Douglas AMA require that we follow those initial AMA management plan statutes as closely as practicable. So you'll see me go back and forth a little bit between ones that say initial AMAs and ones that say subsequent AMAs. In some instances, the structures might be slightly different, but I'll try to make sure I am pointing out those differences. So here you can see pursuant to Arizona Revised Statutes 45-563, the director shall develop a management plan, and I'm going to skip around here a little bit, and shall adopt the plans only after public hearings. So we'll have a formal adoption process for a management plan. And the plans shall include a continuing mandatory conservation program. So the conservation programs we're talking about are regulatory in nature. These are not voluntary. And those conservation programs will be designed to achieve reductions in withdrawals of groundwater. That last line, reductions in withdrawals of groundwater, is our mechanism here. That is the tool that we use in order to improve the aquifer conditions in an active management area by reducing withdrawals of groundwater. All right. So the other piece on the screen here is how some of these pieces fit together. We've talked a lot about in previous meetings about the management goal and the development of that. Today, we're going to be focusing on the management plans And in future meetings that we'll have down here, we'll be talking about each of the individual conservation programs. So the way these fit together is that the management goal is a high level, big picture thing. What are we trying to do in this active management area? And the management plan is our regulatory document that contains the tools and the strategies that we use to move toward that goal. So the policies in the management plan are informed by that management goal, and the conservation requirements are the conservation programs are the specific requirements that allow us to reduce withdrawals of groundwater in that active management area to move toward the goal. So what we're really going to be focusing on in the next handful of meetings here are those second two pieces, that management plan and those conservation programs that'll allow those aquifer conditions to improve over time in the active management area. Yes.
Can you please read for us what the management goal is? As I don't know if I missed a meeting or missed an email, but the last I saw, it was incredibly vague, and I don't know if that's where we ended. Because it, as I recall, it referenced the management plan as being part of the management goal. So that's a little
It's a good question.
awkward.
So we held a hearing back in June on a proposed management plan, on a proposed management goal. We did receive a request for ADWR to consider rehearing a review on that management goal, and that request is still pending. So I'm not going to be able to talk too much about the management goal today, but we wanted to have this meeting. I'll talk a little bit later in a later slide about the timeline we're on. We wanted to have this meeting and start at least laying some of the groundwork for a management plan, even while that review was still pending, because we are going to be on a tight timeline to meet our statutory requirements for the management plan. So as we get into some of these later meetings, we'll be able to talk a little bit more specifically about the management goal. I apologize for that. Okay, so now we are on statutes that are specific to Douglas, and this is exactly that timeline. So not later than 2 years after the designation of a subsequent AMA, the director shall promulgate, promulgation is our formal adoption process for a management plan, shall promulgate an initial management plan for the active management area. So by statute, by law, we have 2 years from the date of the establishment of the AMA to complete our adoption process for that first management plan. That gives us a deadline of December 1st of next year. So exactly why we wanted to come here now, even though the goal is still under review, we wanted to come here now and start having some of these initial conversations about what strategies might be in the management plan, what types of things belong in a management plan, and how we might approach management plans and conservation programs for the Douglas AMA. There are some specific statutory requirements around what is included in a management plan for a subsequent AMA. One is if there is subsidence and fishing, if it is necessary to preserve the existing supply of groundwater for future needs, or that land subsidence or fishing is endangering property or potential groundwater storage capacity, the plan shall include, and shall means must, we have to include measures for reducing withdrawals of groundwater. Again, that's consistent with those standard management plan requirements. So the way we'll focus these conservation programs that we'll discuss is kind of with an eye toward that of reducing withdrawals of groundwater. Next slide, please. Thank
Can I
you.
just ask a question about that one?
Sure.
Has the director determined that or not?
We haven't or Ben, maybe you can help me with this one. We haven't issued a formal determination on that. I don't know if that would be something that would be a part of the management plan or how exactly that would work.
Probably would be that, but we can get back on that, and we would probably want to look back on the order establishing that.
The question was whether there had been a formal determination on subsidence and fishers. What I can do, I have a slide a little bit later that does show evidence of subsidence in the Douglas Active Management Area. We'll talk about that a little bit later. ADWR has been tracking a particular subsidence feature in the Douglas area for a long time. The next item here is related to water quality. This isn't one we're going to cover a lot today, but this is one that we'll come back to at a future meeting. If the director determines that active management is necessary, because the use of groundwater is resulting in actual or threatened groundwater degradation, the director shall, in cooperation with the Department of Environmental Quality, include in the plan a program for prevention or amelioration of groundwater quality programs. So that is, like I said, I'm not going to focus on this particular item too much today, but we will bring some additional data on groundwater quality for a future meeting.
Hello. How do you determine what our aquifers contain at any one time?
I'm not sure I followed that.
How do you determine how much water is in an aquifer to determine that you need to do any of this stuff?
I will come back to that. So I'll talk in a few slides about a groundwater model that is going to be developed.
And who does it? You?
ADWR creates groundwater models, yes. Right, so a management plan. So what is a management plan? Like I mentioned earlier, the management plan is the specific regulatory document for an active management area. So a Douglas Active Management Area management plan is specific to the Douglas Active Management Area, which, yeah, means there might be some similarities to other management plans. There are other tools that have worked well in other areas, but there's also opportunity here to provide customization and do something unique that better fits the needs and the kind of unique character of this area.
Have you made arrangements with a neighbor from the south, how they're gonna regulate the water they're using? Because all this doesn't make sense unless we get cooperation from that side.
Yeah.
Sure, and we've definitely heard that concern. Active management area requirements are established in Arizona state statute, and those requirements apply within the boundaries of the state of Arizona.
But no Mexico. They have as much to do with our water supply as anybody else.
Can you tell me when the last time was, or if you've done a hydrology study in the Douglas Basin?
I don't know that off the top of my head. I don't know that off the top of my head. I know our hydrologists are actively working to gather additional data to develop a groundwater model for this area. I'll talk about that timeline a little bit later in the presentation.
In terms of Mexico, isn't it true that the flow of the water is south, so that AP is actually more affected by the way we use the, I don't know if that's true or not.
I'm not perfectly familiar. I'm not a modeler, I'm not a hydrologist, but what we'll do is I'll talk with our hydro folks and see if I can provide more information on that. That may have been in a previous presentation that I did out here. I'll follow up on that. We may have additional presentations from them, particularly as the model development comes together. They'll want to be in communication with the folks down here. So we'll certainly make sure we're bringing that information down in future meetings.
But I always do think we need to start with ourselves first, then if we do, then.
Just following up on that commentary, I know there was a recent 12 News report that addressed the Attorney General's disagreement or disappointment that the director of the ADWR was not doing the hydrological studies in rural areas as is required. Is there any more you can say about that?
I wasn't a part of, I know ADWR responded to those statements from the Attorney General. ADWR has done hundreds of hydrologic studies over the years. So there are many, many, many hydrologic studies that are available on our hydrology e-library on our website. So I think there's an area of disagreement there. So management plan. A management plan, like I said, is the specific regulatory document for an active management area. So we'll develop a specific management plan for the Douglas AMA. What you're gonna see on the screen here is a structure that we've used in other active management areas. We wanted to lay this out here today as an example, not necessarily as something that it has to be for the Douglas AMA, but rather showing an example of a structure that's worked well for us in the past and providing some examples of the type of information and the way we structure these documents. Sorry, blanking place here, 16. So the first section in a potential management plan is typically some kind of an executive summary. Management plans are long documents. Each of the 5 management plans for the initial AMAs was around 300 pages. So these are long, intensive documents. The best use of a management plan is typically as a resource document rather than trying to read it cover to cover, although I would be thrilled if you guys chose to read these cover to cover. So the purpose of that executive summary is to lay out a little bit of an outline of where you can find information in that management plan. Here's what the different chapters are. Here is where you can find information about agricultural, municipal, industrial water uses, or water supplies and demands, or assured water supply, or whatever the case may be. That executive summary really serves as your starting point in order to point you to the actual information you're looking for. Then we move into kind of our real information chapters. There's a lot of background information in a management plan. So chapter 1, we start with hydrology. You guys have already asked a lot about that today, which I'm thrilled about because it's super interesting and also is really important. So a management plan contains information about the hydrology of a basin. We would certainly include information about how water flows. I just don't happen to know that off the top of my head. So we would, in that initial management plan hydrology section, include information about the data that we do have, the data gaps we might have, and how we might go about collecting that data over time. And we would include information about our timelines for model development and also information about water quality in that chapter. Chapter 2 is typically a little bit more of a mathematical analysis. So the water supply and demand. What types of uses are we seeing in the basin, and what types of supplies do we have in the basin? We know in the Douglas AMA, we are largely groundwater dependent, but there is a very small amount of surface water. There is a very small amount of effluent generated in this basin. So we'll talk about all of that in the supply and demand chapter in the management plan.
How do you define a sector?
So sectors are defined in a management plan. The typical sectors we look at are agricultural, municipal, and industrial. And I'll actually have later slides where I'll talk about each of those. In chapter 3, we have underground water storage, savings, and replenishment. More commonly, this chapter is referred to as recharge and recovery. And I know that recharge is definitely an area of interest for the folks here. So that's definitely a chapter that we're going to want to work on with the local community and understand how enhanced recharge might be approached in this active management area. Next slide, please. Chapters 4, 5, and 6, I have additional slides on each of those. 4, 5, and 6 are a real regulatory chapters in the management plan. So the way those have typically been structured is there's a little bit of a narrative at the beginning where we kind of explain what the programs are. And then toward the end, in italicized language, we have the legally enforceable language, the actual regulatory language for what those conservation and reporting requirements are. Agricultural conservation programs apply to irrigation grandfathered rights holders. Municipal conservation programs apply to municipal water providers. And industrial conservation programs, our industrial conservation program kind of ends up being a catch-all for anyone that's not irrigation, anyone that's not a municipal provider. So that'll include things like mining, dairies, airport, those types of things. And we'll talk a little bit more about that again on the later slide.
Does municipal mean only like a city, like Douglas?
Correct.
Or does it include subdivisions?
So if the water provider is providing water to 15 or more connections or 25 or more year-round residents, then they are classified as a municipal provider.
Does Arizona Water have to comply with that?
Yes.
Because they don't get any of their water from this place.
And we are in discussions with them and have been working with our legal team on how those specific requirements would apply within the boundaries of the active management area. Thank you. Chapter 7. Chapter 7 is a really important chapter. So this is, and I know it sounds dry, but implementation, compliance, and support. This is an important chapter because this is where individual folks can get information about exceptions. So when we write a conservation requirement that is supposed to apply to an entire basin, there are inevitably unique circumstances where folks might not be able to comply with that conservation requirement for some very valid reason. The statutes allow us to consider, we have two different mechanisms to consider adjustments for specific individuals who might need either additional time to comply with their conservation requirement or just might need a change for some reason to the conservation requirement. So the chapter 7 will include information about those variances, which is an extension, or those administrative reviews, which allows customization of the conservation requirement for specific reasons. That chapter will also include information about how compliance is calculated, information about how ADWR approaches enforcement and the types of enforcement authority that we have. And we'll also include information there about how folks can be involved, either in terms of contacting staff with specific questions, or in terms of being engaged more broadly with things like the Groundwater Users Advisory Council that will be established in the AMA.
Where does the oversight come from for those specific programs?
So those are authorities laid out. So, sorry, there's a little bit of difference depending on those. So if we're talking about administrative reviews and variances and compliance, those are authorities laid out under ADWR's authority. So if folks had an issue with how a decision was made there are often appeal processes for a given decision, or when people could reach out to the state.
Legal.
Yeah, or folks could reach out to the state.
Because typically in a government program like that, once you get further down the road, somebody calls in, with an exception, and the government they just ignore it. And
So
you don't have any recourse other than hiring an attorney.
sure. So with an administrative review, for example, if ADWR denies an administrative review, you could appeal that decision.
To who?
Is that right through OA, I think? Do you
I
know?
believe so, yeah.
Yeah, it's the Office of Administrative Hearings.
And then to the Superior Court.
Okay.
Yeah.
All right. The final chapter in this kind of typical structure that we've used for management plans is a water strategy chapter. And this is a chapter that I personally find really interesting. So this is the chapter where we actually discuss the active management area and discuss the outlook for the active management area. This is more of the kind of thought and outlook for the active management area. What can we expect in terms of supplies and demands for this area? What are some potential voluntary strategies that we could look into, or additional things that we might consider in the future for this active management area? This is kind of the forward-looking piece of the management plan, where we're really thinking about, okay, we've done all these things with the conservation programs for this management plan. What are the areas that we need to consider for the future?
What is the goal of like that?
So the management goal would certainly be considered as a part of that water strategy. So our discussion around how we approach this active management area, how we think about the strategies that might be relevant for a given active management area are certainly going to have to take that goal into consideration, right? If we're moving toward the goal for an active management area, that goal is going to inform the types of strategies that are applicable for a
The
given area.
goal would not be modified, it would be the same goal.
Right, correct.
Is there ever a chance to modify the goal? Because if you're really successful at something, you may want to change that.
I don't believe we currently have a mechanism in statute for changing the goal.
No, but I think the plan would be the more effective way to make a change.
What I'm saying is, what I'm getting
Oh,
at
I'm
is
sorry.
like, say, 10 years from now, when you feel like you're reaching that goal, you should be able to modify that to reflect current conditions, or if there's a major shift, like Canal, for example, gained a lot of population, right? That should change what you do. And so that's why I'm asking.
Yeah, so I guess I would say that a lot of, you're saying that would change what you do, and I would argue that what you do is spelled out in the plans. And the goals inform that, and that's a reason to have a flexible goal. Because the plans constitute what you do, and you want to have room to change that. And I think we provided for a plan every 10 years, so that would give you an opportunity to make changes through a new plan.
Right. But you just said the goal isn't flexible.
No, I mean, it'd be a reason for the goal to be written flexibly, but you cannot change the goal under current law. Yeah.
Thank you.
But legislatively, you could change it.
Legislatively, we can change anything.
Can you give in this context, give a definition of assured water supply? Is that for all the users in the AMA or new developments?
Well, I'll come back to that in a little bit.
So this is a plan that meets the law, statutory requirements. How often is this reviewed and updated as things go? We've got many characteristics in these chapters that change over time, so to her point, ideally this would be reviewed on some annual, semi-annual basis, meaning 2 years.
The proposal for the management goal is that there would be a new management plan every 10 years, and that matches what the initial AMAs, the cycle that the initial AMAs used for management plans. It takes time for these things to go into effect, and then takes time for us to be able to observe whether those conservation programs are actually having any observable impact. So we don't want to move too quickly on those to make sure that we're actually giving things time to play out.
10 years is a long time to go to sleep. I understand something's slow, something's fast.
We all know that this is one big aquifer and your plan covers basically this watershed, whitewater drop. But we also know that our recharge is mainly snow or winter precipitation. Within this watershed, there's probably a dozen sub-watersheds some are doing better than others. And people live on that and use the different sub-watersheds. So if they start doing a good job, or there's a significant difference between the water draw or the condition, the aquifer level on one sub-watershed versus the other, is everybody going to be treated the same? So those are concerns that I have. The other one is that as we tighten our belts and we have the desire to have a healthy watershed, healthy outlook, but we're competing with Mexico that has none of that. So as we tighten, how much can we tighten before somebody's gonna say, look, Agua Prieta and this part of Sonora is growing like crazy, and the water demands are astronomical. They're gonna come from our aquifer. There's gotta be something that monitors the sub-watersheds and the conditions on a kind of frequent basis so we can figure out what's going on. And there's gotta be somebody, some entity, some group to start working with Mexico to limit. As we save water, we don't wanna ship it south. And they're already using a lot of water. So it's not really fair to penalize us to help them grow.
And your hydrology study wouldn't be accurate then, if you're not taking in Mexico.
So I'll say, I say both of these are somewhat hydrology issues, and we do have some information, albeit, limited, of what's going on in Mexico, and that does get incorporated into the hydrologic model. I'm not a hydrologist, but I know they do incorporate what's going on in Mexico into the overall model. So we will be, in some way monitoring that. Same thing if you're talking about these sub-basins or small watersheds within it, that would be part of the hydrologic modeling, which I'm aware is, I have no idea how to actually do that, but I know that's what they do. But I will say in terms of what Mexico does, I mean, we're the state of Arizona. We don't have the power to regulate Mexico any more than the state of Sonora can regulate you folks. So, we can't go in there and regulate them. In terms of working some international agreement or understanding, that'll take folks maybe on the congressional level to do that. It's not something we can do as a department, but we understand that concern. It's just, it's out of our jurisdiction.
It's a shared water table. And you can't take half the cup and you can the other half the same way. So there's entities, there's groups and organizations, the International Boundary Commission and others. And it's your responsibility to share that concern with our congressional people and get them to work out something, because all we're going to do after we do everything you say, we're going to replenish the health and increase their water, their aquifer. And there's no hope for us to even ever get better. So if it's an international, congressional, whatever it has to be, you guys should be leading that train to DC. It's beyond what we can do.
That is a major point. We should not be penalized on this side for what's happening on the other side. And that should be an important issue to be at the top of the list.
If I could say, yes, it's an important issue. We did the AMA because of what we saw here. When we looked at I live on Frontier Road. When I moved there were maybe 4 pecan orchards. How many are there now? There are brand new, I don't know, hundreds of acres of pecan orchards on our side. We were scared for ourselves. Yes, Mexico is right there, but we saw what we saw here. We looked at Riverview, excuse me, but they were just eating the water. They were just swallowing. And unfortunately, Wilcox didn't pass there. So we just looked at what we saw here. I'm sure Mexico needs us to protect their water. I'm sure they do. But right now, what I saw here, it was scary because I have a well. And I want to live with water. I want my neighbors to live with water. I want the small farmers who've been here for ages to live with water. The small ranchers who've been here forever to live with water. So yeah, it was here that I saw, in this valley, Sulphur Springs Valley, Cochise County, Arizona. Yeah, Mexico may have a problem, but we have a problem ourselves And we better start here, and then we can talk English, Spanish, or whatever languages we need to help each other protect what we need to live, because we all do.
We're in full agreement with everything you said. We have the same goals, the same desires. But the problem we have is that we have a diminishing water table. It's without our ability, without their management saying you can impound water, you can have water retention structures to replenish our aquifer, it's not gonna happen. There's no happy ending until we work with Mexico. And I think it's
I'm just saying, let's begin here, and then let's reach out, because if we're beginning and we're doing, then we could say, hey, you know, hola,
So let's, I appreciate the conversation. It's certainly feedback we can take back and consider. But as we've kind of emphasized, this is, what we're talking about here is state authority, and we have this authority within the state of Arizona. I'm gonna go ahead and move on from this particular topic. Like,
Can I just ask this, is that I know where I am, there are millions and millions of trees that have been planted since August 30th of 2022. There are millions and millions of grapevines that have been planted since that time. For people that you find are not in compliance, okay, with everything is said and done, will there be accountability for those people? And who will take care of that, holding them responsible?
sure, and I know our compliance team at ADWR is already looking into some instances of that sort of thing. I can't speak to specific examples or things that are, yeah. I can't speak to specific examples or things that are ongoing and that are under current consideration with our compliance team.
Sure.
But there is a process that we work through with inspections and potential fines of up to $10,000 per day.
But can I ask you, is that when you look at people that the finances are not an issue, 10,000 a day is nothing, all right? But when you have so many trees, I mean, here we are all concerned with water, all right? And I talked to people in your department, my understanding is that they would actually rip them out.
Well, so let's say if you're in, this would follow a full investigation by the compliance team. And if they
Sure.
found out in fact that, you know, because there's that moratorium on irrigation that went in, if they planted new irrigation, put in new trees, and it turned out to be illegal, and it's not for sure because there is that substantial capital investment allowance that could, but so let's say it was illegal though. If it was illegal and there's expansion of irrigation, they would not get any grandfathered rights for those acres, so they would not be able to legally water those acres anymore. And then we do have that fine system that Natalie mentioned. And how that usually works is that they'll be assessed a fine, and then that will count against the cost of them removing whatever the crop is or the tree. So they will then remove the tree. But that's in a scenario like that. I don't know if that's gonna happen, but that's how that could play out.
All right, thank you.
So, if we take the trees out, they're supposed to be given carbon credits. So are we gonna have that come in and get on for taking trees out?
I'm not sure that I understand.
Climate change.
Climate change, trees.
We're encouraged to plant trees all the time.
Yeah. And,
I think what is being referred to specifically here is like these pecan orchards and that kind of thing, where it's crops and large acreages of trees. I think that's different than some trees that you might be watering around a household or something like that.
I understand that, but they keep encouraging you to plant trees and all these people jetting around in the big jets, they buy carbon credits, they plant a tree. So,
It's the irrigation.
You realize that most of these places they planted trees were already farms.
Well, again, man, we were just giving a possible scenario, and if that was the case, then that probably is illegal irrigation, so it's fine, yeah.
But they were farms.
All right, let's go ahead and move on. We are, a lot of the way through our time, and I want to make sure we're covering the information we need to. So what you can see on the screen here is a visual that describes or provides a little bit of an overview of the statutory requirements for the initial AMAs. So again, Douglas is a little bit different. The statutory requirement for a subsequent AMA is that we follow the statutes of management plans 1 through 5 and the other AMAs as close as practical. But we don't have specific structures around management plans 1 through 5 in the way that we do in the initial active management areas. So over time in the initial active management areas, what you can kind of see here, without going line by line or anything like that, what you can kind of see here is that additional requirements came in over time, that subsequent management plans include more complex requirements and increasingly stringent requirements. So this may be something we want to consider for the Douglas Active Management area, to copy some of this strategy for the Douglas AMA, where we start out relatively basic, relatively simple with this first management plan, and then add complexity and add more strict requirements over time. We'll go into some additional detail on these items in the next slides. So chapter 4 covers the agricultural conservation program, which applies to irrigation grandfathered right holders. So again, irrigation, applying water to 2 or more acres of land to produce plants or parts of plants for sale or consumption. Really specific definition. There is an exemption to these requirements for some irrigation grandfathered rights holders. By law, those folks who are between 2 and 10 acres are called exempt IGFRs, exempt irrigation grandfathered rights. So they're still required to obtain that IGFR, they're still required to apply for that right, but once they have that grandfathered right, they are exempt from measuring and reporting requirements. And as such, they are exempt from conservation requirements for those very smallest farms, up to 10 acres. In general, in the other active management areas, we have what we refer to as the base program. This is kind of our most straightforward type of agricultural program. This is an allotment style program. The way this has been structured in the other AMAs is that a water duty, so an acre foot per acre number, is calculated for each irrigation grandfathered right. So each farm gets a water duty based on the crops that were grown in that historic period for that farm. So when I say historic period, I'm referring to that 5-year irrigation period prior to the establishment of the active management area. There are flexibility provisions which allow for a little bit more water to be used in some years, a little bit less water to be used in some years, and you can bank those credits from year to year. The general idea here, and what ADWR might put out as a starting point, again, is this idea of starting slowly. Modest conservation requirements starting out, and then move toward more stringent conservation requirements over time in subsequent management plans. There is certainly also the option to develop new programs that are specific to the Douglas AMA. We have that statutory authority to be creative here. So what we would hope to hear from the local communities as we go into future meetings, as we start talking about more specifics on agriculture in particular, is are there ideas that folks have on how can we structure a specific conservation program for ag that might function well specific to the Douglas AMA, specific to kind of the unique nature of agriculture in this active management area. Something that I personally have observed with the Douglas active management area is that it's very different than the other active management areas in that there's a lot more percentage of acres with center pivots or other types of efficient irrigation technologies here. So that might be something we take into consideration as a part of developing a kind of customized agricultural conservation program for the Douglas AMA. Municipal conservation program. I'm not going to spend a lot of time on municipal and industrial today. We have a timeline slide a little bit later in the presentation where we lay out how we're going to go about developing these programs, but I want to recognize that agriculture is our largest sector by far in this active management area. The list you see here is a list of all of the municipal water providers we've identified in the Douglas active management area. So our intent there is that we'll be reaching out to folks at those providers, making sure that they are aware that they'll need to also obtain a withdrawal authority for municipal providers. That's a service area right. We'll be working through public meetings and specific outreach to those folks to start to develop a municipal conservation program. The typical municipal conservation program that we see in the active management areas is what we call a GPCD program. So that acronym is gallons per capita per day. Basically, per person in that service area, you assign a number of gallons. And the design of that is with either over time or with subsequent management plans that GPCD might go down over time so that you're seeing increased efficiency, increased conservation over time in that service area. Municipal water providers are also required to comply with what we call LMU, lost and unaccounted for water. So this, the idea here is that your meters should be accurate and also your pipes shouldn't be leaky. So all providers are required to comply with lost and unaccounted for requirements. For small providers, that's limited to 15%. For large providers, that's typically limited to 10%. And that is something that's tracked on an annual basis.
Yes, ma'am. Why is Bisbee and NACO water in Bisbee, even on this AMA, their water is, that's all out of the San Pedro Basin. That has nothing to do with this basin at all. Why is it up there?
And we understand that they receive their water from outside of the basin. However, AMA requirements apply to the geographic footprint of an active
That's
management
only
area.
on the,
So
only people that are Bisbee is on the north side of the 191. The south side of 191 are not allowed to vote in this last deal. So they're exempt completely from your AMA. So you should throw Bisbee and NACO both off of this AMA.
we're working through.
You should throw it off.
We're working through the details of how those specific requirements may or may not apply. And we'll be working with those individual providers to
Why?
ensure that those requirements are clearly communicated with them.
Simple question.
Plan's not done yet, they're just developing it.
Next slide, please.
You got till next year to finish it. It's 10 years, look at it.
So
Well, what happens?
one of the suggestions that people had was forming a new water district in the Salt Spring Valley. And while that was not popular in some of their public meetings, there is still a lot of support for that. How would that play into this? Is there room for a new water district?
So it would, there could be specific requirements around that, and it would depend on the structure. I don't remember the details of that proposal, whether it was suggested that it was a physical district, whether it was like physical water lines going to individual households and that kind of thing, or whether it would be hauling water. And that would make a difference. There would also be details that would need to be determined about the Douglas Basin boundary and the Wilcox Basin boundary, and making sure that water was not moving in particular from Wilcox into the Douglas Basin. So, because there would be prohibitions around that. So it depends on a lot of the details that if that is something that seems likely that it's going to come about in the future, we would want to work closely with those folks kind of from the outset to make sure that any regulatory requirements were met.
So that kind of goes back to George's question too, though, in that, as you said, we're not supposed to transfer between basins. So if the provider well was in the Wilcox Basin for that proposed district, that would be a problem. But the well for Bisbee is not, is in a different basin. So that's kind of the main concern there. Okay, thank you.
Thank you. All right, industrial. Industrial can be confusing for a lot of folks because this does end up being our kind of catch-all category. So if someone is not receiving water from one of those municipal water providers that we described, and if someone is not using water for an irrigation purpose, so that 2 or more acres, right? Then they may be categorized as an industrial user. So the types of things we see in our industrial users in the other AMAs, you can see some of those examples on the screen. Sand and gravel, metal mining, power plants, cooling facilities, dairies, feedlots, those types of things. I skipped the one at the beginning because this actually tends to be our biggest water user in the other AMAs, which is turf facilities. So things like parks, golf courses, cemeteries. A turf facility in the other AMAs is defined as an area that has water-intensive plants that is 10 or more acres in size. The easiest example there is maybe a park or a golf course. Sometimes large HOAs fall into this category. What this particular conservation program does is lays out some basic conservation requirements around efficiency. A good example of the types of requirements that are applied in other AMAs is requiring landscaping in rights of ways to use low water use or native types of plants. Generally avoiding waste or reusing or recycling water where possible, not using single pass cooling, using low flow plumbing fixtures. So some of these kind of general requirements for all types of industrial users. Then we also have specific requirements for individual subsectors within this category. So in the other active management areas, we lay out specific conservation requirements for golf courses or other turf facilities, or for power plants, or for mining, or for dairies, for example. So this tends to be a kind of complicated program because we have all these kind of various categories of folks that it might apply to. Where we might want to start for the Douglas AMA with an industrial conservation program is thinking about what are those largest users. There are a couple turf facilities throughout the basin. The only other kind of major thing I know that is maybe a small amount of mining, and there's an airport that may fall into this category. There would be specific things that we might look at as potential subsectors that we might identify for the Douglas AMA. So this is certainly something that we would be doing some inventory on in terms of water uses around the basin, and would certainly be wanting feedback from folks in terms of what types of subsectors should we be focusing on here.
Will the prison be included?
That could potentially be included. It could also be potentially captured under one of the municipal water providers.
Would huge orchards be considered industrial agriculture?
Those are classified as irrigation, 2 or more acres, applying water to 2 or more acres of land for plants or parts of plants for sale or consumption. So since the nuts are for sale or consumption, those are irrigation. So those would fall under the agricultural category. Good. All right.
Curiosity question. As far as time check, how far are we along with your presentation?
That's a great question. Oh dear, we are gonna try to move along. I'm gonna skip ahead of this. We already talked a little bit about this. We already talked a bit about water strategy. I promised I would circle back to assured water supply. So, assured water supply applies in active management areas. There are 7 criteria that you have to check all of these boxes to get a determination of assured water supply. Let's see if I can list them all off the top of my head. Oh boy. They are physical, legal, and continuous availability, that the water is of sufficient quality, that the provider has financial capability, and then there are also requirements around consistency with the management plan and the management goal.
But that's not geared towards development.
That is geared towards development.
Yeah.
So a subdivision of 6 or more lots would be required to obtain a determination of assured water supply prior to building. In an active management area, assured water supply, this is a permitting step. In most of the state, adequate water supply is a notification step for folks, where someone can get a water report that says, yes, you have adequate water supply, or no, you don't have adequate water supply. Cochise County is a little bit different because Cochise County is what's referred to as a mandatory adequacy jurisdiction. So in Cochise County, you can't just get the water report and it says yes or no. You are required to get a water report that says yes, adequacy. You're required to check 5 of those boxes in order to get a determination of adequate water supply in Cochise County. So this area was subject to a lot of these requirements prior to the establishment of the AMA. Some of the criteria are analyzed a little bit differently in an active management area, but a lot of these requirements were already in place for Cochise County and the Douglas AMA because it was already a mandatory adequacy jurisdiction. It was already required a permit for assured water supply. 1 second. So in adequacy, there are the first 5 criteria that apply. In assured water supply, there are 2 additional ones. Consistency with the management plan, which we're obviously talking about developing, and consistency with the management goal, which again, we'll come back to at a future meeting. There would need to be rules developed for the purpose of laying out how ADWR would determine the criteria around physical availability and consistency with the management goal for the Douglas AMA. So that's going to be a whole separate process.
When it comes to assured water supply, if those 6 or more parcels are within a municipal area, CCNM, is that going to require the same type of analysis?
So a new subdivision or a new split of 6 or more lots would require a determination of assured water supply. I hope I said that correctly.
Yeah, and you might be going at it, the providers are a designated provider. And so just a water provider, yes, in your scenario, they would need to show that. But the water providers can also become designated by basically establishing all those criteria for all of their water supply. So if there's a subdivision built within that designated provider's area, the designated area, it's basically just taking a cut of what has already been proved to be an assured water supply.
So maybe a different way to say that is there are 2 ways to get that determination of assured water supply, either at the subdivision level or at the provider level.
But either way, the same criteria must be met.
Yeah, so if a provider is designated, then they have a certain volume under their designation, and they can serve water within their service area as long as they stay under that volume. For a subdivision level, a developer might want to just prove a water supply for their specific subdivision, and they can do that with a certificate of assured water supply rather than a designation. So there's kind of two ways to go about that. Good. All right, model. Oh, yes.
Is there any way to provide that assurance without a plan yet in place?
I think the most important way to provide the insurance is having the hydrology model in place, because that's basically what we will measure whether or not that water is in fact assured for 100 years. So I think the most important step is development of the hydrologic model, because that's basically, I guess, the tool in which to measure whether that physical availability is there.
So what happens there?
That's a great question. Do you know again?
That is a great question. There are ways that we can consider some of these criteria in the absence of a groundwater model. I talked about how this area was already a mandatory adequacy jurisdiction.
I can also, yeah. So that will help. Also, let's say a developer comes in and wants to build a subdivision. Once we develop our model, we will basically require them to use our model to demonstrate it. Until that's developed, we'll require them to fund their own model in order to demonstrate it. So we don't just take their word for it. They're going to have to prove it to us, and they'll have to basically pay for and develop their own hydrologic model that our hydrologist will analyze to make sure it's accurate and fits all our criteria and requirements. So that's what could theoretically happen in the interim.
And to that point, Douglas is already, according to the ADWR, has an adequate water supply. Will that change?
So the city of Douglas was deemed adequate at the provider level, but that was under adequacy requirements. So there will need to be an additional determination there to make sure that they meet the assured water supply requirements, because those criteria are analyzed in slightly different ways.
So that would probably be them applying to become a designated provider.
Yes. Yeah. Under assured water supply instead of that. Yes. All right, really good questions, everybody. I really appreciate all the engagement and the thought about this. What you see on the screen is a timeline. It is a long timeline because groundwater flow models are intensive things. So where we are starting right now is that our hydrologists at ADWR are currently working on what they refer to as hydrogeologic conceptualization. And that is a really, really fancy way of saying that they are currently working on taking measurements to understand what this basin looks like, what types of soils here, how water moves in those types of soils, where the bedrock in the basin are, what types of structures are underground, where there's variations in that bedrock, where is the land surface in relation to that bedrock, and how does that change over the space of the AMA. So our hydro folks are currently gathering a lot of that data, gathering the existing data that we have around water supplies and demands in this basin, and also identifying any potential gaps in the information that we have where we might need to gather additional data. In the beginning of next year, what they will do is bring all that data together and start constructing what they refer to as a numerical groundwater flow model. And what that means is that it is a large model that takes all of those physical characteristics into consideration and basically uses math to solve for how water moves within that aquifer. So that, you'll see, the beginning early next year, that takes a long time. That is a complicated and difficult process. And in the beginning of 2025, we'll begin what we refer to as a focused calibration. The calibration process is where we look at the model we've constructed and look at real data. We look at water levels from wells within the basin, and we see if what we're seeing we would expect from the model actually matches up with real life data. And if it doesn't match, we figure out why not, and we adjust our model to make our model better based on that real data. So we're doing a lot of work throughout this process to make sure that what the model is showing us matches what happens on the ground. At the end of 2025, as we've worked through that calibration process, we will prepare model files for publication. We'll write up a report describing the results of the model and how it all came together. We expect to publish that model in 2026. I know that's a long timeline. When that model is published, like Ben said, folks in the basin will be able to download those model files and use those model files for things like well impact analyses and assured water supply purposes. All right, I'm gonna skip ahead a little bit. There is some additional information that we'll provide at future meetings, again, related to land subsidence, and actually pause on this one, and on historic water use in this basin. We'll definitely come back to a lot of this, because this is gonna be important context for how we develop our conservation programs in the AMAs. The reason this is important context is this is our baseline, right? So we have reported data from the Douglas IMA from 1980 on. So we can look at that information and use that as a baseline to help understand where we need to go from here. We talked at the beginning about how the real focus of the conservation programs in a management plan is to reduce withdrawals of groundwater. So if we're reducing, here's our starting point. And that what we'll want to kind of focus on is how can we design these conservation programs to apply downward pressure to those groundwater withdrawals over time to move the AMA toward a more sustainable place.
Will this be on your site?
Yes.
To that point, it's good that you have that data, the data of the non-expansion area, because earlier it was discussed that, you know, we've got all these trees coming in, a lot of the agriculture coming in. And I want to make sure that I'm clear, we do want to protect the water for the individual user. But we do, it was, the trees that were planted was done within the INA. And so it wasn't like the wildcat development. This was being watched and there was some oversight there. So I just wanted to make that clear. Just because the other thing is that, you know, when we start talking about future plans, it's easy to push forward with a lot of regulation and think that we didn't have any regulation before. And that's why I mentioned, because it's easy just to over-regulate and think that we were never regulated. And we have it.
Sure. And it's a good point. The irrigation non-expansion areas, if you were going to be irrigating, you were required to irrigate on a footprint of land that had an irrigation authority under the INA. The same is going to be true going forward, except that your folks who are legally irrigating under the INA are going to be required to obtain an IGFR, an irrigation grandfathered right, instead of that irrigation authority, irrigation grandfathered right to continue legally irrigating under the AMA. So there was a regulatory structure there. The difference between an INA and an AMA is that in an AMA, we consider volumes as a part of the regulatory structure. In an INA, we only look at acreage. You can, as long as you have an irrigation authority for that acreage, you can use as much water as you can beneficially use within that footprint. There's no volumetric limits. In an active management area, we look at the types of crops that were historically grown, and we do establish a volume limit for that acreage. So there is a little bit more clear method for establishing kind of caps on the total water use in an active management area where there aren't those types of restrictions in an INA.
I understand it under the INA, if they're able to strip the land that was just, desert as opposed to, grandfathered in. Is this still true of the, NMA?
So I think what you're asking is the irrigation footprint still, there's still an irrigation expansion prohibition in place?
What about stripping the land? I thought that was a regulation against, stripping the,
So in an active management area, just like in an INA, you cannot bring new acres into irrigation. So if those acres were not irrigated in the last 5 years, or if they can't demonstrate substantial capital investment, they won't be able to be irrigated going forward.
okay.
Now, that might be different than actually clearing the land. Maybe there's a little bit of nuance in the language there.
I'd just like to clarify that the land she might be talking about may have probably had an irrigation authority. It just hadn't been irrigated in 20 years. New people bought it, put it into production.
So this is an important piece of nuance, and I appreciate you helping clarify that. Irrigation authorities from the Douglas INA do not automatically carry forward.
I understand
Yeah.
that. This is pre-AMA.
Yeah, so in order to be eligible for an irrigation grandfathered right for the AMA, you must have had an irrigation authority and also have been using it in that prior 5-year period, or be able to qualify for substantial capital investment.
I have a very good question for you, ma'am. 1978 to 1985, said it was 75 to 85 was when the INA granted the grandfathered water rights in. We thought we had grandfathered water rights in. Now you're saying in the past 5 years, if we irrigate, we now have, for another $75 per well, we will have grandfathered water rights. In 10 years, what's to stop you from coming in and saying, we dissolve all this and voted it out and you're all gone, get out? I want to know that.
So this is, the requirements that we're talking about today are laid out in law. These are not things that we have flexibility around. The role of the department is to implement those laws.
But prior to this, we also thought it was law. Now it's no longer law and you've changed it. So what is the format this on down the road before we can change it again and say, we're gonna change this to, I don't know what, but you're out. Pick up your toys and go home, boys. What's to stop the government from doing this?
The legislature certainly has the authority to change laws. However, at this time, an active management area is the highest level of regulation for groundwater in the state. There is no mechanism for an active management area to go away. Active management areas are permanent. So there is not currently a way that this area would become something different than an active management area.
At this point.
Now, I was operating under the impression that if we got a voter initiative out there, we could make this AMA go away.
Yes, and they threw it out on a technicality.
And I was told we could apply and get more petition signed and get it on the ballot to remove the AMA. Is this in fact true or false?
Sir, as in my understanding of the law, because this is under state statute, how this was created, is that if you did get a petition, it would likely have to be a statewide petition because you'd be changing state law, not a county, not something that's done on the county scale.
Well, it was done on the county to begin with.
But it was pursuant to state law statute. So basically, under the current statutes, there's no mechanism to undo it. So you'd basically be having to do a ballot initiative that changes state law. There's also, I would say that I don't think anyone's sure about this, but that's my understanding is that it would have to be a change of state statute. And just as Tempe can't change state law to do something that only, just neither can Douglas itself. It'd have to be a statewide initiative, which I know would be incredibly burdensome and difficult, but that's how I understand it. Because the mechanism that created it, although it was a vote within this area, that the authority to do that was directly from state statute. So basically, you need to be changing state statute to undo it. And that usually requires a statewide petition. Again, this would be kind of a new thing to happen, so I can't say this for sure, but that's how I understand it.
So you're saying that once the voter initiative is voted in by the people within the area that voted it in cannot change it. Is that what you're saying?
They can if it was a voter initiative purely based off of the authority within the county itself. The voter initiative, in order to happen, it wasn't the standard voter initiative. It was basically a product of state statute.
Do you have documentation statutorily that states that?
Oh, yeah, the only reason the vote happened was because of state statute. So usually if there's a petition like that on just a scale that's county or smaller, it can only affect what the county has authority to do. And Cochise County is not the authority to create or uncreate an AMA. That's derived from state statute. So because that power derived from the state statute, it can only be undone with whoever has the power to undo a state statute, and that's not Cochise County, that's the state. So it would have to be a statewide voter initiative. This is, but through the powers for voter initiative under the state constitution. This was not one of those.
Communicate with the county government on this.
Then why did the board of supervisors have to approve it if it was going through the state?
So what I'd like to do, sorry, Ben.
No, I'll just say that these are questions nobody really knows the answer to because it's a very unique situation. But I can't speak for the county, I don't know, but that's my understanding.
So what I'd like to do is, I know we're short on time here. We understand that a lot of folks are concerned and disagree with the existence of the AMA. That's not what we're here to talk about today. The AMA exists, and ADWR's requirement is to implement the statutes associated with that AMA that currently exists. There is not a mechanism in statute to remove an AMA, so it exists, and ADWR is obligated to, for example, begin developing a management plan. So I want to bring the focus back to that and make sure that we're talking a little bit about the additional things that we're going to be talking about over the next several meetings. We're going to get into the weeds here about the management plan. And like I said, the management plan is a really critical piece of regulation for an active management area. This is our opportunity to really customize things for this area. We have heard you that Douglas is different than a lot of areas. And the issues that are here are different than the other AMAs. And so we'll really want your engagement here to make sure that we're creating a management plan that's responsive to that. And I'm not gonna be able to do that without help and feedback from all of you. So that's really why we're here, and that's why we're gonna hold this next series of meetings. So I wanna focus on that and make sure that we're getting through this tonight and talking through this management plan structure here.
So, there's other AMAs in other counties, on Santa Cruz County. So are these same rules applying for the other areas? And you're telling them that they're having to change?
So each active management area gets its own management plan. The other 5 active management areas actually just completed the adoption of their 5th management plans last year. So they all got brand new requirements, many similar to what we've talked about today, in those areas as well.
Okay, so your little book you have, is that for water deal or is that for your little book you have?
So my statute book is, this is specific to, this is Arizona revised statutes. This is specifically Title 45, which has to do with water, but it lays out the statutes that apply to active management areas across the state.
So like if we had to do something, like with our conservation easements, or not our conservation easements, our coordination planning with NRCS, or whatever we need to read that book.
So when we're talking about the management plan, we might include consideration of collaboration with NRCS or other organizations like DEQ as a part of the requirements of that plan. Yes. Good. All right. quick timeline, because I know we are just about out of time here. So today, we are in September of 2023, and like I said before, we have a statutory deadline of next December, next year, December, to adopt a management plan. So we've got a lot of work to do between now and then. Our next step here is that we will hold a series of public workshops with individual workshops focused on each sector. So that first workshop, the biggest sector here is agriculture. So our first workshop is going to focus on agriculture, and we'll start to dig into some of the details of specific conservation requirements for the Douglas AMA at that workshop. So we will start holding those workshops over the next couple months. We have here on this timeline, October through January. We will also, once we kind of work through those series of workshops, we will also hold a public meeting regarding additional topics of interest in this area. Things like, I've heard a lot of interest in assured water supplies today. We can certainly have a conversation about that. We know there's a lot of interest in this area about things like recharge. We'll have a conversation about that. Things like voluntary measures and best practices, we'll certainly want to consider those types of things. Those are the types of things that'll go into that water strategy chapter. We may want to consider opportunities for grants or funding and that type of thing in those discussions as well. By March, we'll want to be following up on some of the framework discussions that we'll have in these sector workshop meetings. So we'll start to fill in some of the details about any frameworks and any proposals we've heard from folks, and actually lay out some of the outlines of what these regulatory requirements will be. And then by April, again, this is not a long timeline, by April, we'll want to start publishing some draft regulatory language. The idea here is that we will publish these drafts, initial draft regulatory language, so that folks can review it and understand what we're proposing for these specific regulations and provide informal feedback outside of a hearing process so that there's time for back and forth. Informal feedback on that draft regulatory language so that we can make sure that we're working through any potential issues there. Next slide. This slide shows our legal adoption process. There is some, so we talked about how we have to adopt this plan by December of next year. The legal adoption process for this is extensive and also includes public feedback. So the first part of that kind of formal process is actually an informal step, but we have to go to the GUAC. So we are required by statute to take a draft management plan to a groundwater users advisory council. So we're working on, or the Governor's Office Boards and Commissions is working on standing up a groundwater users advisory council for the Douglas AMA. A draft management plan would go to that advisory council and they would be required to comment on it, to provide feedback on that management plan before it is promulgated. So after we review that document with the GUAC, we would issue a hearing notice and go into a hearing. So again, another opportunity in this process for public comment, for public involvement. There's a formal comment period associated with the hearing, and after that, there would be findings from the hearing. We would respond to specific comments and concerns we heard at that hearing, and potentially issue an adoption of that document. After that, there are notices that go out, and at least 2 years after those notices regarding the conservation requirements and the management plan go out, then those conservation requirements would actually go into effect. So it's a long timeline in general. It's kind of a short timeline for developing this. There's going to be a lot of detail and a lot of discussions that are going to need to happen over the course of the next year. And we're really looking forward to working with all of you to make sure we're finding areas of compromise for Douglas. Goodness, I've been talking too much. Sorry, excuse me.
Can you say where the GUAC's at as far as like applications, are they, when is that gonna be formed?
It's a really good question. So applications for a groundwater users advisory council, those applications are online on the boards and commissions website. Last I heard, we had received 5 total applications for 5 vacancies on that council. So if there are other folks who are interested in serving in that type of capacity, there is certainly space for additional applications for those roles. The last I heard, the governor's office was considering those applications. That is outside of ADWR's purview, so I don't necessarily have an update on timeline on that.
So they don't have a deadline to appoint by.
They don't have a formal deadline to appoint by, but we are statutorily required to review that management plan with the GUAC. So we would need a GUAC to be in place by that time.
Right, but that's a year from now. You would think they would want the GUAC members appointed, I don't know, in the next couple months?
Yeah.
So they can start, functioning as a board and meeting each other if they don't already know each other, all that kind of stuff. Okay.
Remember, your application's only online?
So the application through boards and commissions is online. I think they have a paper copy. I'm not positive about that. That is outside of ADWR's purview.
I prefer paper, I can go back on it.
Sure. So the for the applications for grandfathered rights, we do have.
No, to be on the board.
So I'm.
Advisory.
Sure.
We can try to find out.
We can follow up and find out about that. I'm not sure about that. I'm not positive about that, but we can find out. Sorry, in the back.
So is the GUAC has all this stuff we're talking about, the public and all that, transform that goal. The GUAC has nothing to do with that at all. It's just at that point in August, whenever they would review what's gone.
So in the question was related to kind of the role of the GUAC in an active management area. The GUAC is an advisory council for an active management area. So they advise, sorry, I'm cutting out here. They advise the ADWR director on policies related to the active management area. That includes things like the management plan. That may include things like grants, if grants are available in the area. In the other active management areas, the GUACs make recommendations on water management assistance program funds that go to individual applicants and also on withdrawal fees. In the Douglas AMA, we do not have the authority to have withdrawal fees, so that role of the GUAC wouldn't exist here. The WMAP funds are funded by withdrawal fees, so that's also a role that wouldn't exist for this GUAC. So it's just a little bit different than the other active management areas in that sense. ADWR would certainly want close involvement and advice from a GUAC, kind of in that formal sense of understanding the views of folks in the area. Yes, these types of meetings are useful, but sometimes it's helpful to have more focused conversations as well.
Well, that's why I kind of, getting on what Sonia's saying, we're going through this process, you're laying out a deadline, and we're not even gonna have that advisory there until the end. So it seems like that needs to happen sooner than later.
I know those conversations are ongoing. I just don't know the timeline on which the governor's office would be appointing those folks. In the background, sorry.
Yes, on the prior slide, I think for about a 3 or 4 month period, October to January, the meetings are also defined as workshops. Are those going to be different types of meetings? Can you tell us what to expect in what you define as a workshop as opposed to a meeting of this type?
Sure, it's a good question, and we have not laid out our specific plans for those meetings yet. It's something we're going to be working on over the next few weeks here. My expectation, my anticipation there is that they would be more interactive than something like this, where today's meeting was a lot of me trying to provide information to all of you. A meeting like that might be more like me laying out a question for all of you. What are the types of goals you might have for an agricultural conservation program? are there concepts that you think might work related to agricultural conservation in this area? It would be a lot more interactive for that type of thing because we'd be looking for a lot more input rather than trying to make sure that we're providing enough information that we're all on a level playing field and can actually have those conversations in the next meetings.
Are those workshops open to anybody or like the agriculture will be
Everybody.
packed?
Those will be, the intent there is that those will be open to the public.
It's up to the ag people to control the.
One of the slides you had, like local farmers, small farmers, do you have a definition of small farms?
Oh, was that the 2 to 10 acre thing, maybe?
Local residents and local small.
Yeah, it was like incentives.
Yeah, I don't remember.
Go back.
Sorry, I don't remember what that specific slide was referring to. Sorry about that. Oh, maybe on the ag slide.
Yeah, that one.
Oh, no, was that?
One, I think it's chapter 5.
Maybe,
I think it's this with the 2 to 10
Chapter,
acres.
go to chapter 8.
maybe it's 8, right?
Yes.
Yeah.
Oh, so I think what we were trying to recognize here is that in this area, we have heard a lot of discussion around the importance of the farming community and small farms to the folks here. So that wasn't anything specific. It wasn't a proposal or recommendation or anything like that. It's just a comment that we have heard already in these discussions. And so it's something we wanted to acknowledge, and it's something we can certainly have additional conversations about as a part of the development of the management plan.
All of this is online, right?
These slides are not online yet, but they will be probably within the next telling me tomorrow. So,
Okay, and the applications for grandfathered wells?
Those are all available online, yes, on our Douglas AMA webpage, yes.
There was a proposal to have the AED said flat fee of $75, is that finalized?
It has not been finalized. That proposal will be going in front of the Governor's Regulatory Review Council. I forget what the C stands for in that acronym. Committee, it's Councilor Committee. In any case, it's going before GERC in October.
So it did already go before them and they make their formal decision next week.
Oh, I missed that. Okay.
Yeah.
So apparently they're making a formal decision next week on that. What I will say is that if you submit an online application today, we have already changed the fee associated with those online applications to $75. So if you submit an online application today, you would pay that $75 fee per application.
As a city representative here, I've seen some of the concerns from the individuals here about either online or through the phone. You know, like this gentleman said, he's not comfortable going back on online application. And then there's some that are gonna call and they might be on hold for who knows how long. I think it'd be a great idea if the city of Douglas, us, partner up with you to give you an office here where these individuals can call in for an appointment and have an hour to discuss this in a personal level instead of through the phone or online platform.
Sure, I really appreciate that. So I'm the active management area director. I have AMA staff who are assigned to the phones at all time. We have a customer service phone number. It's 602-771-8585. And folks are staffing that phone line from 8 a.m. to 5 p.m. every day. Sometimes it'll go to voicemail, but I am on top of my staff, making sure that they are responding to those voicemails promptly. That's something that I hassle my staff about constantly. So, we do have a customer service line. The response times are pretty quick on that. The other thing I'll say is that we do have a computer set up here in the Douglas Library, where folks can log on either for those virtual office hours that we've mentioned, where you can actually have a video call with someone at our AMA office, or you can do the online applications using that computer in the Douglas Library. If folks would like more personalized discussion, especially around these meeting times where we're gonna be down here, we'd be happy to schedule extra meetings with folks while we're down here in town. I've already done that with some folks from the county and from the city of Douglas. And we would also be happy to schedule specific phone calls with myself, with other staff, to make sure that folks are able to get their questions answered. I hope that helps.
I just think there's more certainty if there's somebody in front of you, giving you the paperwork, helping you out, telling you this is how you're supposed to do it, this is what we need from you, instead of missing something, because that's like the folks here are saying, if they miss that deadline, there's, we're out of luck. So I think it'd be a better way to coordinate with the city, and having somebody here physically, and they can man the phones if they want. We have phone lines, in our offices. They could be manning those phone lines while they don't have appointments. But I don't think it's fair to the people when it's their livelihoods that they can't have somebody there to help them out.
And this is our AMA.
And we're definitely trying to do,
Great idea.
we're definitely trying to do what we can to address those concerns. And I appreciate the comment. To the extent we can, while we're here, we're certainly happy to schedule additional meetings with folks while we're here. Perhaps that's something we can kind of put a call out for ahead of future meetings, if folks would like to schedule dedicated time with us. Something I'll say about the applications specifically is that ADWR does have the ability to ask questions about the applications. So if we get an application and maybe someone didn't fill something out quite right, or we're missing a piece of information that we need, we'll send a request back to you and let you know, can you clarify what's on this map? Can you clarify this location? Can you clarify this parcel number? We'll reach back out to make sure that we're adding to any additional information that we might need with those applications. And we can continue to gather that additional information even after the deadline. So that's an important piece of nuance. We really want people to at least get those initial applications into us by the deadline. We'd obviously like them to be as good as possible. That helps everyone out. But if there's something missing, we would have an opportunity to reach back out and make sure we're amending those properly.
Yeah, I also want to emphasize that the applications don't need to be perfect before that deadline. They just need to be in, they need to be submitted. And that's a really important thing. And if it's not perfect, that's okay, we'll work with you, but you gotta get them in that time.
But I think it's a great idea to have local presentation, because often people do, and even in terms of Spanish English, and I don't know, I think, for me, it's great to have a human being. And you guys are in Phoenix, and I know you're doing a hard job, and you're working hard, but if you could coordinate with someone in Douglas, I think your idea is right on. That was it, I'm sorry.
Thank you, I appreciate the comments. All right, we are at 6:16, so we've already run over our allotted time here. I would just really like to thank you all. These have been really great questions. I did not get through the material that I assumed would take only half the time today. So, and I think that's a testament to you all that you are engaged, you are thinking about this, you are asking really great questions, and we're taking, I deviated from what I planned to talk about today because they're good questions and I think it's important information. So thank you everyone for being here tonight. Thank you for being so involved. We will make sure to be providing additional information on our website. We'll email everyone and provide more information about those upcoming meetings. Thank you so much for being here tonight.